Ayan. So, how many are you in this class? Alam niyo ba?
40 po ata, sir, or 40 po.
40? Wait, wait. Yeah, okay, sige. 40. Hmm, 35. So 35 are present here tonight. Give me the names of those who are absent. Sino pwede magbigay?
Yung iba po ata, sir, is wala pong kuryente po. Just like Pamplona po, sir.
5 sila sa Pamplona?
Yung isa lang po yung kilala ko dun, sir. Not sure about other municipalities po, sir.
Sige. So give me the names nung 5. May ikaw na lang, Mr. Alan. Bigay mo sa akin yung 5 wala dito tonight. No? Okay?
Noted po, sir.
Okay, sige. Thank you. Sige, let's proceed. I'm sorry. Late kong na-upload sa LMS yung ating topic for tonight kasi medyo mahaba siya. Wait lang. Okay, so let's proceed to a new chapter. Ay, may balita ba kayo sa ano nyo, sa midterms nyo? Anyone?
Midterm exam, sir?
Yeah, midterm exam.
We're not sure, sir, but rumor has it na face-to-face po. Pero waiting for approval pa po ata. Pero in-encourage na po kami na mag-secure ng school ID po namin, sir.
Wait, hindi ako updated sa nangyayari. Ano? Pati ba class natin? Hindi naman. April 6 to 8 is tentative date for your midterms para alam ko kung kailan ko ipipesto yung mga quizzes natin. Sige. Thank you kung sakaling April 6 to 8 man.
Date po ba yung tinatanong, sir? Kala ko yung mode.
Yung date. And meron na ba instructions regarding face-to-face? Magkaklase ba face-to-face o hindi?
So far, wala pa po, sir. We're waiting for an update from the program chair po.
Okay, sige. Kasi kung face-to-face, baka mahirapan ako kasi ang biyahe ko is from Carig to St. Louis. I'll be traversing heavy traffic. So, malilate ako kung sakali. But then again, inform me if merong changes kung anong mangyayari later. Okay? Sige, so I appreciate the attendance. 35 out of 40 is good for me. Kasi previous class ko, to tell you honestly, binoboycott kasi ako. So, hindi nakakalahati yung nag-attend. That's why, with them or for them, ang klase namin is every time they enter the class, nakaayos sila. So, they are well-dressed. Every time they attend the class, naka-on ng camera. So, that is for them kasi nga, ang daming absent. Okay? So, instead of me reporting na na-boycott ako sa dalawang class to the dean and to the program chair, okay, which I could have done, hindi ko ginawa. So, because of that, nag-iba yung approach ko sa kanila. That's why sinasabi ko lagi before na always dependent ako kung ano yung papakita nyo sa akin. Kumbaga. So, napansin ko kasi na out of a class of 30 plus, 13 lang ang nag-attend. So, imagine, wala pang kalahati. Okay? Out of the class of 46 or 40 plus, 22 lang ang nag-attend. So, wala pa rin kalahati. That's why the rules with them, so far as my class with them is concerned, is iba. Also, I will no longer discuss for them. It's pure recitation. So, that's why it's important that we maintain this attendance kasi I will always depend on how you parang kung gaano kayo interested sa class. Diba? If hindi kayo interested, syempre, I'll find a way na maging interested kayo, which is through recitation. Diba? Pag may recitation, alam nyo walang discussion, magbabasa kayo ahead of time. So, ganun kayo magiging interested sa class. I hope hindi tayo aabot sa ganun kasi kayo, okay pa kayo eh. 35 out of 40, it's actually good pa. Pero nonetheless, give me the names of the 5 students, okay?
Sir, pa-accept daw po si Celine Yabes.
No, just give me the names of the 5. Okay? Yun lang.
Sir, joining daw po siya, hindi daw po siya makapasok.
May nakita ba kayong joining dito? Wala eh. Kasi kung meron siyang joining ganyan, di syempre admit ko. Hindi.
Yung core po email na lang daw po gamitin niya, sir.
Dapat yun ang ginamit niya una pa lang. So wala pa rin. Okay? Just give me the name of the 5. 5. Basta yung sinabi kong 5 kanina, 5. Okay? Whether late or not, give me the names of the 5.
Yes, sir. Hinahanap ko pa yung iba.
Mr. Alan, okay? Sige. Let's start na. Obligations of the vendor. Obligations of the vendor. Wait lang, nagkamali yung pag-edit ko. Sorry. Okay? So, let's proceed to first section or the general provisions of the obligations of the vendor. So, actually, even before this article or this chapter, okay, we can already identify the obligations of the vendor by looking at the first paragraph when we were able to define the contract of sale. So meron ka nang may identify dun na obligation ni vendor or ni seller. Okay? So let's proceed to the first paragraph. Okay? Article 1495. The vendor is bound to transfer the ownership of and deliver, as well as warrant the thing which is the object of the sale. So if we can go back to the first article, the contract of sale before. I think we have the word to transfer. I think we have the word to deliver. Okay, as one of the obligations of the vendor. Now proceeding here to Article 1495, nagdagdag siya. So, the vendor also warrants the thing which is the object of the sale. Okay, so isa-isayin natin yan later. So, ito yun. Okay, to transfer ownership, of course. You have already understood that from the first article, from the first time that we defined the contract of sale to transfer ownership. Okay? And how do we transfer ownership? It's not by sale, di ba? We do not transfer, or the buyer does not acquire, or the seller does not transfer ownership by virtue of the sale or by virtue of the deed of sale, di ba? The deed of sale or the sale is only a title, as we have discussed previously, di ba? It is by tradition or by delivery that we transfer ownership. Okay? And that is the second obligation of the vendor, to deliver the thing. Okay? The third one, to warrant against eviction and hidden defects. What is it? Meron bang ano? Question? Wala. Sige. To warrant against eviction and I think there is a specific chapter for this, but to give you to shed light, ibig sabihin parang si vendor, okay, guarantees that you will not be evicted or your ownership is guaranteed. Meaning, hindi ka, let's say for example, I will sell a piece of land or a parcel of land to Mr. A. Okay? By virtue of that sale, I am warranting that Mr. A will not be evicted from that land. Meaning, hindi matatanggal yung ownership ni Mr. A dun sa land na yun. Or, hidden defects, or na yung quality ng lupa, or yung if it's for agricultural purposes, okay, they guarantee the quality of the land. Okay? Kasi, kaya tayo maraming kaso because of dito. Okay? Because there are a lot of instances, okay, where an owner would sell a piece of land to a buyer, the buyer not knowing that that piece of land was either already sold to another person, that that piece of land was already encumbered, meaning that that piece of land was made as a real property mortgage. Kumbaga, ginawa siyang collateral. Okay, there is an encumbrance to the title of the land that the buyer was not made aware of. Okay, kaya tayo nagkakaroon ng mga kaso because of these instances that the buyer may be evicted from the land sold. Okay? Iba pala ang may-ari. Or, hindi na pala siyang may-ari that time, nung biyenta niya. Okay? Kapag nangyari yon, the buyer can file a case against the seller. Okay? Or, pwedeng yung nag-claim na may-ari will file a case against the buyer and the seller. So, there are a lot of scenarios that can happen because of this thing we call warranty. Of course, this is natural and logical because as an owner or as a seller or a vendor, okay, you must guarantee that you, at that time of delivery, you are the owner or you have the right to transfer. Diba? If ma-recall nyo yung previous article natin before, we said that at the time of delivery, the seller must have the right to transfer or deliver the property. Hindi kailangan na at the time of perfection, merong right si seller or si seller yung may-ari ng property. Hindi kailangan. Okay? Basta ang importante, at the time of delivery, the seller has the right to transfer or deliver the property. Yun ang importante. Whether siya yung may-ari at the time of the perfection, meaning at the time there is already a meeting of the minds, okay lang na hindi si seller yung may-ari. Pero at the time of delivery, dapat si seller yung may-ari. Why? Because of the thing we call warranty. Okay? Because the seller will warrant to the buyer that I am the owner of that property. Or you will not be evicted of your ownership over that property. Or that thing or that property is of quality. Okay? There are no hidden defects. Okay? That's the third obligation of the vendor. Number 4, this one, I think you already know under your obligations and contracts to take care of the thing pending delivery with proper diligence, or with what we call diligence of a good father of a family. Diba? The diligence of a good father of a family. Of course, it doesn't mean naman na when you had already meeting of the minds, or when the contract is already perfected, napapabayaan mo na yung, let's say for example, sasakyan. You sold your car to Mr. A. Okay? So, nag-agree na, pumayag na si Mr. A. And you also agreed that you will deliver the car at a specified date. So, hindi pa ngayon. It doesn't mean that once the contract is perfected, wala ka nang pakialam dun sa sakyan. Of course, you have to maintain it. Okay? You have to take care of it with the diligence of a good father of a family. Okay? Number 5, to pay for the expenses for the execution and registration of the deed of sale unless there is a stipulation to the contrary. This one's very interesting. Ang sabi dito, it is the vendor who must pay for the expenses for the execution and registration of the deed of sale unless there is a stipulation to the contrary. Okay? But in reality, guys, to shed light into you sa real practice, okay, it's not always the case. Actually, ang nangyayari, si buyer ang nagbabayad. Why? Kasi pwede naman. Kasi ang sabi dito, unless there is a stipulation to the contrary. So, pwedeng pag-agrihan nila na si buyer na lang magbayad. Ang sinasabi ko lang is, hindi nangyayari yung general rule, which is si vendor ang magbayad. Okay? Always, in the real world, always, or most of the time, si buyer ang nagbabayad. Why? Because si buyer, gusto niyang matransfer yung property sa kanya kaagad. That's why siya na ang nagbabayad ng expenses for the execution and execution of the deed of sale. Meaning, siya ang gagawa ng deed of sale, pupunta sila sa notary public or sa abogado na may notaryo, at sila na din ang pupunta sa ROD, sa BIR, sila lahat ang magbabayad. Kasi pabayaran mo pa yung if it's not a regular business of selling land, we call it capital gains tax. Babayaran mo pa yung capital gains tax sa BIR. Okay, merong yan requirements. Pagkatapos mo sa BIR, pupunta ka sa ROD para maipalipat yung, let's say for example, we stick with the first example, yung lupa. Lupa yan. Okay? Notary. Pagkatapos mo dyan, sige, share ko na rin kasi alam ko din naman. Okay? Deed of sale sa notary. Okay? Deed of sale, notary, no? Under the BIR kasi, under the, I don't know if it's a circular or a guideline, na dapat within 30 days, okay? Within 30 days from the execution of your deed of sale, dapat ma-declare mo na siya sa BIR. Ano ma-declare? Mabayaran mo na yung capital gains tax. Okay? Babayaran mo yan sa BIR. Kapag hindi mo siya nabayaran ng within 30 days, mayroon kang penalties, surcharges, or what not, kung ano yung i-impose ni BIR. Pero, ang ginagawa dyan, ang deed of sale, ginagawa yan kapag meron ka ng pambayad ng capital gains tax. Siyempre, kasi 30 days lang yung leeway mo to pay your capital gains tax. After mo sa BIR, kapag nakakuha ka na ng what do you call this one? Authority, mag-i-issue si BIR kasi ng authority to transfer. So, ito ngayon yung ibibigay mo kay Registry of Deeds. So, Deed of Sale, BIR, si Registry of Deeds. Okay? Pag nakuha mo na yung authority to transfer, dahil nabayaran mo na yung capital gains tax at lahat ng i-require ni BIR, CROD na ang next. Okay? CROD na para ma-facilitate mo na yung transfer ng lupa sa pangalan mo. Okay? Yan. Ganyan ang proseso ng pagbili ng lupa or pag-transfer ng title sa pangalan mo. So better para sa inyo na rin to have a real application. Okay? Dapat yung binibili nyo ng property or let's say for example, lalo na real property or yung mga lupa, dapat yan nakapangalan sa seller or sa owner. Kasi madami actually, kaya madami tayong kaso kasi madami yung nagpa-falsify ng documents. Okay? Pinapapirma. Let's say for example, yung owner is sobrang matanda na hindi na siya makapagsulat, hindi na siya makakalimutin na. Ang ginagawa, pinapa-fingerprint na lang, tapos ipapa-fingerprint sa papel, not knowing that that paper is a deed of sale, okay, selling the property. Madaming ganyang senaryo. Actually, iba-ibang klase. Okay, that's why it's very important pag kayo or yung parents nyo bibili ng lupa, titignan ang title ng lupa. Okay? That's one of the obligations of the buyer. Okay? Tignan mo yung title. Dalawa yan eh. Dalawa yan. Kapag sinabi kong title, dalawa yan. Meron kang owner's copy. Meron ka ring e-copy. Ganito. Ang owner's copy, ito yung hawak ng may-ari. Okay? Ibig sabihin yan, kung matagal na yan na titulo, luma na yan. Okay? Luma na yan. So, medyo brown na yan. Okay? Hindi mo makikita dyan kung nasangla or nabenta na yan. Hindi mo makikita dyan sa owner's copy. Saan mo makikita? Dito sa electronic copy. Okay? Electronic copy ng title. Dyan mo makikita kung na-encumber yan. Ibig sabihin, naging collateral or real property, real estate mortgage. Or kung nabenta na yan, dyan mo makikita sa e-copy. Sir, paano? Naka-annotate sa likod ng title. Kasi imagine, yung owner's copy, nasa owner yan eh. Usually, nakatago yan, nakafile yan sa mga cabinet ng mga parents nyo. Nakatago yan. Okay? Pero itong e-copy kasi, dyan mo makikita kung merong mga transactions na nangyayari regarding dun sa title. Okay? Kasi pwedeng sinangla yan. Pwedeng binenta na pala yan. Okay? Saan mo makikita? Sa likod ng e-copy, hindi sa owners. Kaya, kapag bibili kayo ng lupa yung parents nyo, tignan nyo yung owner's copy. Pag nakita nyo, malinis yung likod, walang naka-encumber, walang nakalagay na kahit ano, kunin nyo yung e-copy. Saan kayo kuha ng e-copy? sa ROD, dito sa Registry of Deeds. Doon nyo makikita kung ano yung mga transactions na napagdaanan ng property. Okay? Kung cleared na siya sa mga utang, kung nabenta ba siya, doon nyo siya makikita. Okay? So yan mga diniscuss ko, that is the practical or the real application. Actually, you don't find this in the law, lalo na yung process ng paglabas ng title. But that is very important kasi lalo na we're talking about the obligations of the vendor. Now I have a question here. What happens when the seller fails to deliver at a stipulated period and such period is of the essence of the contract? Then he has no right to demand payment of the price. Of course, gaya nga nung nasa obligations and contracts tayo, and even still connecting with the contract of sale, the buyer and the seller have their own obligations. Okay, if the seller fails to deliver and there's a stipulated period and that period is of the essence, meaning it's one of the basic considerations or the main considerations for the existence of that contract, then that seller has no right to demand payment of the price. Ibig sabihin, si seller yung at fault in this case. Okay? What is the effect of non-delivery by the seller? The buyer may ask for resolution or rescission of the contract or to cancel the sale. Of course, if hindi niya dineliver despite your agreement, huwag ka rin magbayad, di ba? Kaya nga sabi natin noon, parang mutual yan or the obligation of the other party can only be demandable once you have complied with your obligation. Okay, if you fail to comply with your obligation, you don't have the right to demand performance or to demand execution or to demand the other party to do his part, because in the first place you failed to do your part. Okay. Delivery is the transfer of two things. Delivery could indicate the transfer of possession and ownership. Okay. But this is when we talk about actual delivery. Okay, because we are placing the thing or the object of the contract of sale under the control and possession of the buyer or the vendee. Okay, but we will discuss later on that there are other forms of delivery, hindi lang actual delivery. Okay, when we talk about the obligation to deliver at the execution sale, okay, paulit-ulit execution sale, so alam na natin na kapag execution sale, okay, there is what we call a judgment debtor. The judgment debtor is not required to deliver the property sold right away. Bakit, attorney? Because the judgment debtor has a period of 1 year within which to redeem the property. Yan nga yung sabi ko before na meron silang right of redemption. They can redeem the property. Diba? If maalala nyo before, we were able to discuss kapag there is a gross inadequacy of price, but it happened in an execution sale, that gross inadequacy in price is valid or it's okay. Why? Because it means that the judgment debtor can redeem that property at that lower price. Diba? Meaning, it will be favorable to the judgment debtor. Yung judgment debtor na yan, yun yung mga naka-mortgage ang kanilang, let's say for example, sasakyan or kanilang lupa, okay, or bahay, and they were not able to pay their obligation, okay, and ang option na in-exercise the seller is to foreclose the mortgage, and by virtue of that foreclosure of the mortgage, meron kang execution sale na mangyayari, doon na mangyayari yung dyan na papasok na siya is a judgment debtor. But before na execution sale, there must be an order or a judgment from the court. Okay, kaya siya tinatawag na judgment debtor. In the meantime, the buyer should not take actual possession of the property. Okay, take note that the right to redeem commences from the day the sale was registered in the ROD. Okay, it's very important to safeguard yourself and your family sa mga ganyang situation. You must be very vigilant. Okay, the buyer must be very vigilant. Hindi naman pwedeng may ibebenta sa'yo na lupa na hindi mo pwedeng makita yung lupa. Okay? Kasi in the first place, kasi madaming ganyan. They will show you the title. Okay? Kasi they will show you the title. Pero if you request na i-visit yung property or na-inspect yung property, magugulat ka na mayroon parang tenants na may mga nakatira palang families doon sa lupa. Oh. Problema mo yun kung binili mo yun. Ibig sabihin, ikaw na bumili nun, nung lupa na yun, ikaw ngayon lang magpapaalis doon sa mga naka-stay doon sa lupa. Eh, under the law, okay, if you are in possession of the land, you are deemed the owner. Okay? Kung ikaw ang nakatira sa lupa na yan, or ikaw ang nagme-maintain ng lupa na ito, ang presumption ng batas, or ikaw nag-exercise ng ownership dito sa lupa na ito, ang presumption ng batas, sa'yo yung lupa na yan. Okay? Sir, paano kung siya naman talaga ang may lupa? Ito naman talaga ang may-ari ng lupa, nasa kanyang title, lahat-lahat, pero siya lang nakatira dyan. Anong dapat gawin nito? File a case in court. Yan. Attorney, hindi ba pwedeng ipabarangay ko, ipapulis ko? Pwede mong gawin. Pero wala silang, lalo na kung advised by a lawyer, hindi mo sila basta-basta magpaalis. Because under the law, mapapaalis mo lang ang possessor ng lupa if you file a case. Okay, either ejectment case or land dispute. Okay? So, mahirap. Okay, that's why it's very important na kapag bibili kayo ng lupa, i-inspect. Kasi madaming ganun na nabenta na pagtingin nila sa lupa kasi nga nasa Manila sila that time or walang time, ngayon lang nagka-time. Pagbalik nila sa lupa, mayroon mga nakatira. Hindi lang isang pamilya, madaming mga bahay sa lupa. Problema mo ngayon kung paano mo sila papaalisin. Okay? Magkakaso talaga yan. Okay? Article 1496, the ownership of the things sold is acquired by the vendee from the moment it is delivered to him in any of the ways specified in Articles 1497 to 1501, which we will discuss later. Okay? So ownership is acquired from the moment of delivery or in any other manner, signifying an agreement that possession is transferred, except when the seller and the buyer agree that the ownership shall remain with the seller until the full payment of the purchase price. Of course, the agreement between the parties or the buyer and the seller is the law between them. As long as it is not contrary to law, to morals, to public policy, customs, it is a law or a force between them. It's a binding agreement between them. Kung sabi nila na the ownership will remain with the seller until full payment of the purchase price, then so be it. Okay? Just like in a contract to sell. Diba? Pero in a contract to sell, it's not a contract of sale. Diba? As we have discussed, contract to sell is not a contract of sale. Okay? You are only promising to sell the property if nabayaran yung purchase price. Kapag nabayaran yung full purchase price, saka ka lang mag-execute ng contract of sale. Diba? Yan yung contract to sale. Or sale on approval, trial, or satisfaction. Meaning that the sale or the ownership of the property, although there is already delivery, will not transfer to the buyer. Okay? The ownership of the property, this we will discuss later, okay? I will discuss it briefly lang. The ownership will remain with the seller, but it will transfer to the buyer upon approval. Okay? Kapag in-approve na ni buyer, then siya na yung mayari. But, kung wala pang approval, the ownership will remain with the seller. Okay? Or, implied reservation of ownership. This one happens mostly in equitable mortgages, which I hope we will be able to discuss later. Okay? Or yung mga implied reservation of ownership. Discuss natin sa kinds ng delivery. Sa one of the kinds of the delivery. Okay? Payment of the purchase price is not, of course, it's not essential to transfer of ownership as long as the property sold has been delivered. Meaning, regardless of whether the price is paid or not, okay, it will not be the main factor for the transfer of ownership. Okay? Ang titignan mo lang dyan is delivery. Okay? Kahit pa iba yung nagbayad nung or nagbigay nung pera or nung pambayad dun sa purchase price. It is immaterial. Okay? What is material is that there is delivery. What is material is that kung sino yung buyer dun, siya yung nasa deed of sale, siya din yung nag-receive nung property na dineliver, then everything is okay. Kasi that happens naman that sometimes the owner of the money used in purchasing an object is hindi din siya yung buyer. Diba? Let's say, for example, very basic example is kapag nag-loan ka. Diba? When you are kapag nag-loan ka, ginagamit mo yung pera ng pinag-loanan mo or yung creditor mo. You are not the owner of that money. Okay? But you are using his money to purchase an object. Okay? That's why it's irrelevant kung sinong may-ari nung owner. Okay? Let's proceed to Section 2, Delivery of the thing sold. Yeah. So, for Article 1497, the thing sold shall be understood as delivered when it is placed in the control. Actually, we're becoming redundant. Na-discuss natin ito kanina. Napapasadahan ko pala. Okay? The thing sold shall be understood as delivered when it is placed under the control and possession of the vendor. This is the general rule. Or this refers to actual delivery. Okay? When the thing sold is placed in the control and possession of the vendor. A very concrete example is when you sell your cell phone. You deliver it, you give it to the buyer, okay, siya na. You transfer the control and possession. Diba? That's it. That's actual delivery. That is law in application. Okay? Let's proceed to the kinds of delivery. So we have already discussed actual or real delivery. Let's proceed to the second one, by constructive or legal delivery. Meaning, there is no actual delivery. Okay? But it is equivalent to actual delivery. Okay, kaya nga siya tinatawag na constructive. Okay? Parang actual delivery. But in reality, wala kang dineliver. Okay, hindi mo dineliver yung property mismo. Number 1, by legal formalities. Meaning, a sale made through a public instrument. Yan. Very concrete example is sale of a parcel of land. Yan, di ba? Take note, public instrument. Okay. Does this mean execution of a deed of sale? Execution of a deed of sale and notarized. Okay? And notarized. Very important yung notarized. Why? Kapag gumawa ka ng deed of sale, that does not make the instrument public. Okay? Private pa lang yan. Private instrument yan. Di ba nga sabi ko sa inyo, it is the notary public who converts a private instrument to a public instrument. Okay? Meaning kasi nga, that document will be made under oath. Meaning, you are swearing na lahat ng nakalagay dyan sa deed of sale na yan is totoo. Ibig sabihin, ikaw ang may-ari niyan, sinasabi mo na sa'yo yan, ikaw ang may-ari niyan. Kasi later on, kapag nagkakaso, madaming pwedeng i-file sa'yo. Diba? One of those is perjury. Why? Because you perjured, you gave a perjured statement under oath. Okay? That's why it's very important na kapag sale of a public land talaga, or sale of a land, parcel of land, dapat public instrument. Meaning, a deed of sale duly notarized. Hindi deed of sale lang. Okay? Number 2, by symbolical tradition or by traditio symbolica. Meaning, symbol to represent the thing sold. Meaning, you are delivering not the property sold or the thing sold itself, but a property or a thing that symbolizes it. Like say, for example, a sale of a car. Okay? Hindi mo naman buhatin yung kotse, bigay sa kanya. You give the key. Hindi ko alam. Give the key. Diba? That is symbolical tradition. You give the key. Okay? Kung sale ng boat or ng yacht, diba? You give the key kung ano man ang ano, diba? Hindi yung buong yacht, okay? Or yung buong car ang ibibigay mo, but the key. Okay? From that moment on, pagkabigay mo ng susi, okay, there is already delivery. Meaning, the ownership is already transferred. Okay? Gaya nung pag-execute ng public instrument, once that both of you have executed a duly notarized deed of sale, the ownership is already transferred to the buyer. Okay? The third one is traditio longa manu. Takes place by mere consent or agreement, or meron itong by pointing. Di ba? By pointing. Pinaka-prime na example niya. Okay? So, hindi mo i-deliver but you're merely pointing. Okay? Hindi mo naman pwedeng gawin sa lupa yan. Kasi ang lupa, the law requires na mayroong public instrument executed para maging valid ang sale mo ng land. Okay? If walang susi ang sasakyan mo, then siguro pwede. Can point. Or, magbebenta ka ng goat or ng baka or ng baboy. Diba? Nandun na kayo sa lugar kung nasaan yung baboy o yung goat o yung baka, and you point. Nasaan dun yung bibenta mo? Ayan. Yan, bibenta ko yan. Kaya na yung bibilin ko, sige. Abot ng bayad, sige. That's yours already. By mere pointing, tradisyo long manu. Tradisyo brevi manu. The vendee has already the possession of the thing sold. The vendee has already the possession of the thing sold by virtue of another title. Let's say, for example, a very good example of this. Okay. Let's say, for example, Mr. A and Mr. B. Mr. A leases the property to Mr. B. So, Mr. B is occupying or in possession of the land as a lessee. Meaning, nag-uupa lang siya. Okay? If later on, Mr. A and Mr. B agreed that A will sell the property to B. Okay? And they agreed, they sold the property. There will, the delivery that is specified there or that takes place there is traditio brevi manu. Why? Because the buyer or the vendee has already the possession of the land, not as an owner but as a lessee. Pero because of the sale, he already possesses the land as an owner. That's traditio brevi manu. Okay? Meaning, the vendee already has the possession of the thing bago pa siya naging may-ari. Diba? Bago ko pa binili yung, let's say for example, bago ko pa binili yung lupa, ako na yung nakatira dun sa lupa. Okay? Pwedeng because of a lease agreement, pwedeng because of a trust agreement, or any other form of agreement. Pwedeng trust agreement din yan. Traditio constitutum possessorium, opposite of brevi manu. So, baliktad. Okay? Meaning, let's say for example, we adopt the same example, AB leases the property to B. Now, if A will sell the property to B, okay, B now becomes the owner. Okay. Pero by virtue of their agreement, A will sell the property, but A will retain the possession of the property not as an owner but as a lessee. Okay? Pwede yun. Okay? Pwede yun. That's the opposite of traditio brevi manu. That's traditio constitutum possessorium. Okay? So, walang actual delivery na nangyayari. But then again, the delivery is in the essence of or the change of the nature of possession of the buyer and the seller. Okay? Yun yung sa traditio brevi manu at traditio constitutum possessorium. Okay? The third one is by quasi-tradition. Okay? Delivery of rights, credits, or incorporeal property. Okay? Or yung sa mga stocks, pwede siya pumasok. Okay? Placing, this can be made through placing title of ownership in the hands of a lawyer or allowing the buyer to make use of the rights. Of course, if you're already invoking your rights, meaning you're the owner. Okay, although there was no actual delivery that transpired, but you're already exercising it as a matter of right, then you're already the owner. Okay? So those are the kinds of delivery. Article 1498 when the sale is made through a public instrument, the execution thereof shall be equivalent to delivery of the thing, which is the object of the contract. If from the deed, the contrary does not appear or cannot be clearly inferred. Let's stick with paragraph 1 first. Ito yung sinasabi natin na sale by legal formalities. Okay? When the sale is made through a public instrument, the execution thereof shall be equivalent to the delivery of the thing. Take note, there is no actual delivery, but only the execution of a public instrument. Yan yung sale by legal formalities. We have discussed this one kanina. Okay? Going to the second sentence, with regard to movable property, its delivery may also be made by the delivery of the keys, hindi keys na keys na susi, of the place or depository where it is stored or kept. Okay? Ito naman yung tradisyo symbolica or symbolical tradition. See, I am already discussing in advance para we can already understand yung mga succeeding articles. Okay? Constructive delivery requires 3 things before ownership may be transmitted. Seller must have control of the thing. Of course, just like what I've said earlier, at the time of delivery, the seller must have the right to transfer the thing or he must be the owner. Diba? Itong delivery na to, since walang actual delivery dito sa legal formalities, tradition symbolica, at the time of the execution of the public instrument or at the time of the delivery of the symbol or yung keys or yung depository. Okay? Dapat seller must have control over the thing. Second one, the buyer must be put under control, of course. That is the essence of delivery. Of course, if you give the key, that means you're giving the buyer the control over the land. Over the car. If you execute the public instrument under oath in a notary public, wala nang bawian yan kasi sworn statement yan that is made under oath. Okay? Kapag nagsinungaling ka dyan, okay, madaming kaso ang pwedeng may file sa'yo. Okay? That means you are putting the buyer under control over the thing. Okay? And third, there must be the intention to deliver the thing for purposes of ownership and not merely for inspection. Of course, natural naman if you are going to execute already a public instrument or a deed of sale and you are going to have it notarized, then that means you have already the intention to really sell and deliver the property. Diba? Kung ibibigay mo yung susi, that means that you really are transferring the ownership of the car. Diba? Or bahay. Diba? Susi. Diba? Hindi naman pwedeng bigay mo yung susi, tapos bawiin mo later on. Diba? The intention must be clear. Okay? There must be intention to deliver the thing for the purposes of transferring the ownership. Okay? So 1498 talks about legal formalities and tradition, symbolica or symbolical tradition. Note that when the sale is made through a public instrument, the execution thereof shall be equivalent to the delivery of the thing which is the object of the contract. Yes, we have already discussed this one. However, in order that this delivery may have the effect of tradition, it is essential that the vendor shall have had such control over the thing sold that is it could have been possible at the moment of the sale, its material delivery could have been made. Of course, kasama na dyan sa paglipat ay sa pag-execute ng public instrument with the deed of sale, okay, is the transfer of the title itself. Okay? Hindi naman pwedeng mag-execute kayo ng deed of sale sa notary public and then the seller will not surrender the title to you or the owner's copy of the original title or the transfer certificate of title. Hindi naman pwede. Okay? Note that the keyword is control and not possession of the land. Sabi ko nga, di ba? You can sell a land na mayroong nakatirang tenants. Okay? Actually, para to shed light, let's say for example, meron kang apartment or hindi na lang para mas maganda, meron kang lupa, sabihin mo na lang. Itong lupa na ito, pinaparenta mo sa mga tao. Okay? Sila lahat yan nag-occupy sa land mo. Actually, you can sell your property kahit merong nakatira dyan. Merong nakalupa dyan. Why? Because you're the owner. Okay? Kapag binenta mo yan, malilipat lang naman sa buyer yung rights mo. Ibig sabihin, since nabenta mo na sa kanya, siya lang yung sisingil ng renta nila. Diba? You can do that. Pero ang nagkakaroon ng kaso kasi is kapag nagbenta ng lupa, okay, merong isang tao na siya ang nakatitle sa lupa, pero iba ang nakatira sa lupa. Diyan tayo magkakaproblema. Okay. Execution of a public instrument or document, of course, it must be notarized. Okay? And delivery is presumptive only. The mere execution of deed of sale in a public instrument is equivalent to delivery of the property if from the deed the contrary does not appear or cannot clearly be inferred. Therefore, prior physical delivery or possession is not required. That's why it is called delivery by legal formalities. Okay? Sale of thing not subject to control of vendor. Symbolic delivery by the execution of a public instrument is equivalent to actual delivery only when the thing is subject to the control of the vendor and there is no impediment that may prevent the passing of the property from the hands of the vendor into those of the vendee. Okay? Meaning, next sale of registered land, of course, kapag registered land yan, or pag land generally, it must be made through a public instrument. Okay? In possession, as part of constructive possession of whole, possession of part is constructive possession of whole. Of course, just like in a land, di ba nga, sa isang lupa, let's say for example, ganito kaluwang yung lupa mo. Okay. Dito mo lang pinatayuan ng construction or ng bahay or ng temporary na building. This doesn't mean that you are only occupying this part. Okay. When we say possession of a part is considered as constructive possession of a whole, yung possession mo dito will include yung possession mo of the whole lupa. Okay. That is one of, meron yan jurisprudence na. Okay, that the owner of a land need not to lay footsteps all over the land in order to say that he is currently possessing the land. Okay. The mere fact that he is possessing a portion of the land, okay, already shows that he is in constructive possession of the whole of the land. Because the land has its meets and bounds. Meron niyang mga boundaries. Okay? If you are possessing a portion of it, meaning you're possessing the whole of it. Okay? Article 1499. The delivery of movable property may likewise be made by the mere consent or agreement of the contracting parties if the thing sold cannot be transferred to the possession of the vendee at the time of the sale, or if the latter already had it in his possession for any other reason. Ito na yung traditio longa mano, yung sabi natin na by pointing. Okay? Or traditio brevi mano. Okay, ito yung that the vendee is already in possession of the property in another form. Okay, like lessee lang siya. Okay, ito kasi gaya ng example natin kanina, ang sabi dito, if the thing sold cannot be transferred to the possession of the vendee at the time of the sale, di ba? Kung nandun kayo sa farm nung vendor, di ba? Nag-agree kayo kung anong baka or kambing or baboy yung bibilin mo. Okay? Hindi naman kasi agad-agad yan na kukunin mo na yung baboy o baka, di ba? So, may pointing ito yung bibenta ko. Sige, abutan ng bayad, pwede. Okay? And then, pag-aalis na, doon na ito-transfer or i-deliver yung kambing, baka, or baboy. Okay? Article 1500 or 1500, there may also be a tradition constitutum possessorium which we have already discussed. Kaya sabi dyan, where a seller continues to occupy the land as tenant, the possession by eviction of law is deemed to be constituted in the buyer. Diba? Just like what I've said kanina dun sa example ko. The seller sold this, let's say for example, land to the buyer. Okay? And the buyer, okay, leases that land to the seller. So the seller now becomes from an owner, naging lessee na lang siya. Okay? So, it is deemed constituted in the buyer. Okay? That's traditio constitutum possessorium. Article 1501. With respect to incorporeal property, the provisions of the first paragraph of Article 1498 shall govern. What's the provision of the first paragraph of Article 1498? Execution of public instrument. Okay, kung balikan natin, 1498, first paragraph, when the sale is made through a public instrument. Yeah. Execution of a public instrument. So kung incorporeal property daw, ang isang form of delivery is execution of public instrument. Okay? In any other case, wherein said provisions are not applicable, if hindi pwedeng execution of a public instrument, pwedeng placing of the titles of ownership in the possession of the vendee or used by the vendee of his rights with the vendor's consent. This one we have discussed earlier when we say when we talk about quasi-tradition. Diba? Quasi-tradition. Article 1502. Last 2-3 articles siguro. When goods are delivered to the buyer on sale or return. It's very important, guys, na kaya ko ina-underline or ina-encircle para mag-guide din kayo kung paano ko iniintindi yung isang article or yung provision. Kasi the words of the law are very particular na kapag na-miss mo yung or nalito ka lang sa isang word, you can be wrong on your answer. Okay, that's why it's very important na hina-highlight yan. Kapag nakikita niyo mga law students, hina-highlight yan, binibilugan, or whatnot. Okay, for you to understand the article. Okay, to give the buyer an option to return the goods instead of paying the price. The ownership passes to the buyer on delivery, but he may revest the ownership in the seller by returning or tendering the goods within a time fixed in the contract or within a reasonable time, if no time has been fixed in the contract. So if we will stick to paragraph 1 of Article 1502, we're talking about a sale on sale or return. When goods are delivered to the buyer on sale or return. Ibig sabihin, the ownership will pass to the buyer. Okay? Pero, pwede niyang ibalik or i-revest yung ownership. The buyer can return the ownership to the seller by what? Returning the goods or tendering the goods within the time fixed in the contract or within reasonable time if no time is fixed. Okay? Returning, binalik mo. Tinanggap ni seller. Tendering, kaya niya sinabing tendering the goods. Ibig sabihin, tinry mong ibalik. Okay? Tinender mo. But the seller did not accept. Diba? Tender. Kaya niya sinabing return or tinender mo yung goods. Okay? Kasi there are times wherein the seller will not accept this one. Okay? But if it's delivered on sale or return, basta ganyan ang term niya, on sale or return, pwede siyang ibalik ni buyer within a certain amount of time or within a reasonable amount of time. Pwede niyang ibalik or pwede niyang i-tender. Okay? Like for example, binalik sa bahay, kumatok ay nag-doorbell sa gate. Doorbell sa gate. Hindi pinagbuksan sa gate. Okay? Hindi tinanggap. Pwede mong iwan dun sa gate. Okay? That is tendering. Tinender mo. Okay? That's delivery on sale or return. Take note, the ownership passes to the buyer, but the buyer may revest the ownership or return the ownership to the seller within a reasonable amount of time or within the time fixed in the contract. The second paragraph naman, when goods are delivered to the buyer on approval or on trial or on satisfaction or other similar terms. The ownership therein passes to the buyer. Okay? The ownership therein passes to the buyer. When he signifies, di ba, I've discussed this kanina, when he signifies his approval or acceptance to the seller or does any other act adapting the transaction. Meaning, when the goods are delivered to the buyer, the buyer does not immediately become the owner of the goods. Unlike delivery on sale or return, wherein the buyer becomes the owner of the goods or the ownership is transferred to the buyer. Diba? So there is already a difference na nakikita natin between delivery on sale or return or delivery on approval or on trial or on satisfaction. If he does not signify his approval or acceptance to the seller, but retains the goods without giving notice of rejection, then if a time has been fixed for the return of the goods on the expiration of such time, and if no time has been fixed on the expiration of a reasonable time, then the ownership will pass to the buyer. Okay? Meaning, so i-consolidate ko na. When the delivery is on approval, on trial, or on satisfaction, the ownership shall not immediately pass on to the buyer. The ownership will only pass to the buyer when he signifies his approval or acceptance, of course. Number 2, if he did not signify his approval or acceptance, but he did not also giving notice of rejection, so ano ba talaga? Pero, ni-retain niya naman yung property. Ibig sabihin, nasa kanya naman yung property or ginagamit niya naman yung property. Then, within a reasonable amount of time, or within a reasonable time, or within the time fixed in the contract, the ownership will pass to the buyer. Okay? That is what we call delivery on approval or on trial or on satisfaction. You can already, from that discussion alone, we can already dissect the difference between delivery on sale or return or delivery on approval or on trial or on satisfaction. And that is what we are going to discuss here in the next slide. Okay? So, tapusin ko lang ito. In O2. Okay? Kapag sale on approval, okay? Of course, as I've said kanina, paulit-ulit, hindi pa man transfer agad yung ownership. Diba? Only upon approval or acceptance, or kapag hindi naman siya nag-approve, hindi naman siya nag-reject, pero ni-retain niya, then ownership may transfer after a reasonable amount of time or after the time fixed in the contract. Diba? Same yan dun sa ito na diniscuss ko kanina. Sale or return naman, ownership passes to the buyer on delivery, but the buyer may revest the ownership to the seller by returning the goods or by tendering the goods, diba? Or the thing. So here are the distinctions. The sale or return is subject to a resolutory condition. Why? Because the ownership has already transferred to the buyer, but then again, by virtue of the buyer or the will of the buyer, the ownership may revert or may be revested to the seller. Okay, that's why it's called a resolutory condition. While the sale on approval or on trial is a suspensive condition, meaning the ownership will not be transferred to the seller, diba? It will only be transferred upon approval or acceptance, or ni-retain within a reasonable amount of time. Okay, that's one of the distinctions. The second one is sale or return depends entirely on the will of the buyer. Diba? Sabi ko nga kanina dito sa discussion ito kanina. Okay? It depends on a resolutory condition that depends on the will of the buyer whether ibabalik niya yung goods or not kay seller. While the sale on approval or on trial depends on the character or quality of the goods. Why? Because it will depend on whether the buyer will accept or approve of the character, the quality of the goods. Siyempre, kung nakita niyo naman na same quality, of same character yung binili niya na goods, then of course you can approve or accept the same. If hindi, then hindi niya accept yung sale on approval, trial, or satisfaction. Kapag on the third distinction, in sale or return, the ownership of the goods passes to the buyer on delivery. Of course, we know that and subsequent return of the goods reverts ownership in the seller. Pero, yung sa sale in trial or in approval, the ownership remains in the seller until the buyer. Yeah, this one we already know. In sale or return, the risk of loss or injury rests upon the buyer. Okay? In sale or return, the risk of loss or injury rests upon the buyer. We follow the principle under obligation of contracts, meaning whoever is the owner bears the risk of loss. Diba? Whoever is the owner bears the risk of loss. Or, yung principle na, Latin na, res perit domino. But I will not recommend that. Ito na lang. Whoever is the owner bears the risk of loss. Mas madaling intindihin. Kung ikaw yung may-ari, syempre, kung nawala yan, ikaw ang magbe-bear ng loss. Ikaw ang mawawalan. Kasi ikaw yung may-ari. Kung hindi ikaw yung may-ari, hindi ikaw yung mawalan. Diba? Very easy to understand. Okay? While in a sale on trial, since on trial siya or on approval, ang sabi natin kapag on approval, hindi magta-transfer yung ownership sa buyer, therefore si seller pa rin ang may-ari, the risk will remain with the seller. Diba? Ang tatandaan niyo lang naman, sino ba yung seller? Ay, sino ba yung owner? Okay? Kung na-determine mo na kung sino yung owner, siya yung may risk ng loss. Okay? That's the fourth distinction. Take note, Article 1502 uses on sale or return. If the contract uses the phrase for sale or return, the intention may be to enter into a contract of agency. Diba? Contract of agency. Kasi either for sale or babalik. That's why the difference of words, di ba? Isang word lang can alter your answer. That's why it's also very difficult to become a lawyer and a law student. Why? Pag pinagkwento mo yung isang tao, tapos incomplete yung facts niya or yung statements niya, or habang nagpro-provide ka na ng legal opinion mo, or ng advice mo, or ng sagot mo, may dinadagdag siyang facts. Mag-iiba at mag-iiba yung sagot mo. Kaya, it's very hard na mag-provide ng legal opinion or legal advice. Kasi depende lahat yan sa ipoprovide mo na facts. But for us, since ito pa lang tayo, okay, always depend on the facts or on the problems you are solving. Kung ano lang yung nandun sa problem, stay on that problem. You operate on that problem. Huwag kayong mag-assume, huwag kayong mag-presume. Okay? Kung ano yung given sa problem na yan, yan lang ang i-consider mo. Okay? Kung wala namang sinabing ganitong fact or ganyang fact, huwag mong i-include. Mas magmamali ang sagot mo. Okay? Some rules, last na ito guys, before I will let you go. Some rules on sale, on approval, or trial, or substitution. Sabi ko kanina, we have already understood this one. Since it's on trial or on approval, risk of loss remains with the seller because the seller retains the ownership. Whoever is the owner bears the risk of loss. Diba? If the sale has not yet become absolute. Except, so there is an exception. If the buyer is at fault, or the buyer has agreed to bear, of course, makikita mo ito sa facts or sa problem. Diba? Kung sinabi sa problem, the buyer is expressly agreed to bear the loss. Then therefore, yung general rule mo, hindi mo i-apply, you apply the exception. Diba? Makikita mo yan sa facts or sa problem. Okay? The second one, the buyer must give goods a trial, except when it is evident that it cannot perform the work intended, of course. Kaya nga, sale on approval or trial, di ba? You have to try or to test it before you will accept it or before you will approve it. Okay? Period for buyer to signify acceptance commences to run only when all the parts essential for the operation of the object have been delivered. Of course, if that is something that you need to assemble before you can operate it or before you can try it, di ba? Mag-i-start lang yung period, di ba, to signify acceptance ni buyer pag na-deliver mo lahat ng components, pag na-assemble niya na yan. Hindi naman kung na-deliver pa lang yung makina or yung isang part, saka kapal, doon mo pa lang gusto na mag-signify na si buyer ng acceptance, hindi pwede. Hindi niya nga matry eh, kasi hindi pa kompleto yung parts. Okay? If it is stipulated that a third person must satisfy approval or satisfaction, the provision is valid. But the third person must be in good faith. Of course, they can stipulate na imbes na si buyer yung mag-approve, pwedeng a third person. Okay? But since prone ito to fraud, the person must be in good faith. If refusal to accept is not justified, the seller may still sue on the ground that the third person is not in good faith, but rather the third person is in bad faith. Okay? Generally, the sale and delivery to a buyer who is an expert on the object purchased is not obviously on sale, on approval, trial, or satisfaction. Okay? Ganito lang yan. Binentahan mo yung expert dun sa object na yun. Therefore, ang presumption is he already knows that object or that thing that he purchased. Okay. Therefore, it's not a sale on approval, trial, or satisfaction. So I hope that's clear, the difference between sale on sale or return, delivery on sale or return, or delivery on approval or on trial or on satisfaction. Next meeting will continue on Article 1503. Questions? If none, let's call it a night. Thank you for listening. Good night, everyone. Good night.
Thank you, sir.
Thank you, sir.
Thank you po, sir.
Thank you,
Thank you po.
Thank you, sir.
Thank you, sir.
Thank you po, sir.
Thank you po, sir.
Goodbye po.
Good night.
Thank you, sir.